Assalamualaikum and a very good day to Dr. Rohana. We are from Group 1 will be discussing the circumstances and the procedure for making an application for an order for security for costs under Order 23 of the Rules of Court 2012. Security for costs can be defined as an order that requires the claimant party to pay money to the court or provide a bond or guarantee as security for their opponent's cost of litigation. Usually, only the defendant can apply for security for costs of litigation. However, the plaintiff may apply for security of costs if the defendant makes the counterclaim. The purpose of this order is to ensure that a successful defendant or plaintiff in a counterclaim will have enough funds to make claims as to costs. Therefore, the court will has wide discretion on whether to order security for costs and must consider all circumstances of the case provided under Order 23 of the Rules of Court 2012.
Good day, I'm Yashusa with the measuring number 270340. Now I'll be explaining on the circumstances for making an application for an order for security for costs under Order 23 of the Rules of Court 2012. In a civil court case, defendants can protect their interests by requesting an order for security for costs under Order 23 of the Rules of Court 2012. These rules allow the defendant to potentially require the plaintiff to provide a bond payment. But there is a catch. This option is only available under specific circumstances outlined in Rule 1 and 2A of Order 23. The first circumstance is when the plaintiff is ordinarily resident outside the jurisdiction where the court is located. Another circumstance arises when the plaintiff, who is not suing in a representative capacity, is a nominal plaintiff suing for the benefit of another person. If there is a reason to believe that the nominal plaintiff will be unable to pay the defendant's costs if ordered to do so, the defendant can seek security for costs. Additionally, according to Order 23 Rule 1 Sub-Rule 1C of the Rules of Court, if the plaintiff address is not stated or is incorrectly stated in the writ or originating summon, the defendant can apply for security for costs. However, it is important to note that this consideration is subject to Order 23, Rule 1, Sub-Rule 2 of the Rules of Court 2012, which states that the court should not require the plaintiff to prove security for costs if the misstatement of the address was made innocently, without any intention to deceive. Lastly, as per Order 23, Rule 1, Sub-Rule 1D of the Rules of Court 2012, if it becomes evidence that the plaintiff changed their address during the proceedings with the intentions of evading the consequences of the litigations, the defendant can seek security for costs as well. In all of these circumstances, the court will carefully consider the entirety of the case before determining whether it is just to order the plaintiff to provide security for the defendant's costs. Decisions to grant an order for security for costs is within the discretionary power of the courts. In the case of Sir Lindsay Parkinson's and Co. Limited, it is well established that under Order 23 and Section 351 of the Rules of Court, the court has the directions to grant or deny an order for security for costs. This discretion must be exercised by taking into account all the circumstances of the specific case. Further, the applications for security for costs aim to protect the plaintiff's interests rather than to impede the defendant's right to effect legal actions. This can be seen in the case of Tan Hui Tin versus Tang Yi An.
Moving on, other than as stipulated in Order 23 Rule 1, Paragraph 1 and Paragraph 2 of the ROC, a party that is defending a claim in court may also make an application to the court for security for costs to be provided under Order 23 Rule 1, Paragraph 2A of ROC, where it appeals to the court that the actual aggrieved person assign his rights to the plaintiff, so he may avoid his liability for costs, or the plaintiff is able to sue because someone contributed to his costs in return for a portion of money or property that the plaintiff may recover in the proceeding. By referring to the case of Takako Sakao, the court made a reference to an English case of Symphony Group, where it laid down the guidelines for the making of a cost order against a non-party, stating that, in general, an order for the payment of costs by a non-party will always be exceptional. As such, with regard to the Singapore case of Nordic International Limited, a two-stage test has been established to determine whether a non-party should be ordered to provide security for the defendant's cause. At the first stage, the defendant has to establish that the non-party contributed or agreed to contribute towards the plaintiff's legal costs in return for a share of the money or property which the plaintiff may recover in the action or proceedings. If the first stage is satisfied, then the issue at the second stage would be whether the non-party is a person against whom a court order may be made and whether it would be just to order the non-party to provide security for costs. For instance, a Malaysian case in the application of security for costs can be seen in Asian Shield Warehousing Sdn Bhd. In this case, there is no evidence of Devi assigning her right to plaintiff or that she had contributed or agreed to contribute to plaintiff costs. Devi is not contributory of the plaintiff and she is not a non-party as stipulated in Rule 1, Order 23 and Rule 1, Paragraph 2A of the ROC has thus no application to the facts of this case. It is pertinent to note that in any event, it is a recognized principle that an order for the payment of costs by a non-party will always be exceptional, and the judge should treat any application for such an order with considerable caution.
Now, I will share on how to apply for a security cost. Generally, Order 22, Rule 1, Sub-Rule 1 stated that the application shall be made by way of notice of application, exhibited with a supporting affidavit to justify the application. For instance, to prove the instances mentioned in Rule 1, Sub-Rule 1, Paragraph A to Paragraph D. Meanwhile, if the application was against a non-party to the cause, Order 23, Rule 1, Sub-Rule 2B stated that the application shall be made by way of a notice of application and shall serve on the non-party personally and on every party to the proceedings. According to the Takako Sakao case, this is because even if the applicant can prove a good reason for the payment of costs to be made against a non-party, he should warn the non-party at the earliest opportunity of the possibilities that he might seek to apply costs against him. And this is an obvious principle of the natural justice. Going on, Rule 23, Rule 1, Sub-Rule 2C of the ROC provided that a copy of the supporting affidavit shall be served together with the notice of application on every person on whom the notice of application is required to be served. Nevertheless, it must be noted that delays defeat the application. For instance, in the case of Ihua Holdings Sdn Bhd and another versus Chin Yu Nam, in this case, there has been an inordinate delay on the part of defendant in seeking security. The court held that the defendant failure to come to court promptly actually deprived the rights of the plaintiff and its opportunity to assess their position in relation to the security before the plaintiff embarked to any real extent on this litigation.
Order 23, Rule 1, Sub-Rule 3 stated regarding the reference in the foregoing paragraph to a plaintiff and a defendant shall be construed as reference to the person howsoever described on the record who is in the position of plaintiff or defendant as the case may be in the proceedings in question, including the proceeding in counterclaim. In summary, the purpose of this clause is to make it clear that the terms plaintiff and defendant in the document should be understood to refer to the actual parties involved in the proceeding, regardless of how they are officially designated or described on the legal records. It ensures flexibility in applying these terms based on the specific context of the proceedings and allows for the inclusion of counterclaims. Order 23, Rule 2 stated regarding manner of giving security. This principle was illustrated in the case of Standard Chartered Bank Thailand and Datuk Mat Shah bin Safwan. The court, pursuant to this application, ordered the plaintiff to deposit a sum of 30,000 ringgit into a fixed deposit account as security for costs on or before 3 September 2001. The court held that it was unless order. Unless order is an order that unless the party perform an obligation by a specific time or period, they will be penalized by the sanction set out in the order. The principle laid down here is that failure to obey with an unless order would be treated as contumelious and therefore would disentitle the litigant to rights which he would otherwise enjoy, which in this case, the defendant defense has been struck out by the court. It is notable that the court possesses an unfettered discretion to order security for costs. This is because an application for security of costs may be important to protect a defendant against frivolous and unmeritorious claims. After all, ultimately justice needs to be served.